Judicial evasion and the status quo on SC judgments. In high-stakes cases, the Supreme Court must ensure that judgments are timely and clear. On October 26, 2018, a three-judge bench of the Supreme Court, headed by the Chief Justice of India, was confronted with a straightforward legal question: whether the decision taken by the Central Vigilance Commission (CVC) and the central government to divest Central Bureau of Investigation (CBI) Director Alok Verma of his powers and functions was legally valid. The question was a straightforward one, because it required the court to interpret three legal instruments: the Delhi Special Police Establishment (DSPE) Act that brought the CBI into existence, the CVC Act, and the Supreme Court's own prior judgment in Vineet Narain. The counsel for Mr. Verma argued that the DSPE Act made it clear that the CBI director had a guaranteed two-year tenure and could not be transferred without the consent of a high-powered committee consisting of the Prime Minister, the Leader of the Opposition, and the Chief Justice of India. This interpretation of the Act was buttressed by the Supreme Court's exhortation, in Vineet Narain, that the director must be protected from political influence. The Attorney General, on the other hand, argued that the committee's role was purely recommendatory, that the power vested with the central government, and that in any event Mr. Verma had not been transferred. As the Supreme Court itself acknowledged what was at stake. Yet this pure question of law took 6 hearings and more than 2.5 months to resolve, and yielded an unclear decision where the court agreed with the principal legal contentions of Mr. Verma, but passed a judgment whose ambit left everyone scratching their heads. Judicial evasion: the Alok Verma case, or CBI vs CBI, as it has come to be popularly known, reveals some of the pathologies that have plagued the Supreme Court's conduct in recent high-profile cases. As indicated above, when Mr. Verma approached the court, the legal question was straightforward: with the CVC and the central government authorized to divest him of his functions as CBI director? It was a question that, when the court finally got around to it, took it no more than 8 pages to answer. Why then did the case take 6 hearings and 2.5 months? A perusal of the court's orders reveals the following. On August 26, the court directed that the CVC finish its pending investigation against Mr. Verma, under the supervision of a retired Supreme Court judge. On November 16, the court received the CVC report in a sealed cover, and allowed Mr. Verma to respond, also through a sealed cover. On November 20, the court passed a cryptic order stating that, for reasons that need not be recorded, we are not inclined to afford the parties a hearing today, and adjourned the case to November 29. It was reported that the Chief Justice was annoyed that some of the contents of the sealed cover had been leaked. On November 29, the case was listed for hearing final arguments, which then took place on December 5 and 6. The court reserved its judgment on December 6 and finally delivered it January 8. It should be clear from the record that there were 2 parallel proceedings taking place in the Supreme Court. The first was Mr. Verma's original challenge to the process of his divestment, that came up before the court in October and was heard in December. The second, which occupied the court through the month of November, and through the now familiar, depressing cycle of sealed covers, was the substance of the allegations against Mr. Verma, that the CVC and the government